these kinds of conversations all the time with folks who are considering going independent. So what this group, it's usually an hour to an hour and a half conversation, so this group is going to speak triple time and get you all of that information in 30 minutes, or apparently 20 to 25.
No, 30 minutes. You guys can take
So the first thing we're going to do to help along that is not go over our bios, but I will tell you who each of us are. I am Holly Portal of Oyster Consulting. This is Teresa Muller of Oyster Consulting. And this is Jim Van Horn of Hirschler Fleischer.
Thank you.
So I'm going to turn it over to Jim first. And
sure.
Say a little bit.
Well, the first thing we wanted to talk about, especially, since we're going to be talking about some of the more boring topics when it comes to going independent, or at least the ones that scare people the most, and that's compliance and legal. And so the previous panel got to talk about all the exciting things, the new technology, the fact that you're starting a new business, you're becoming an entrepreneur. It's then when the client comes into my office or into the office of Polly and myself, and they start asking us questions. And Teresa, we were just having a conversation about some of those questions that we get, and you can start to see little beads of sweat on people's brow. The reason for this is because you have to recall that the fact that the legal framework and the compliance framework that we deal with every day is very foreign to you, even if you've been in the business for decades. And that's because this was all created back in 1934 and 1940. And that's essentially what we're still dealing with today. And so when I'm talking to you about the contract provisions, or when I'm talking to you about the regulation SP or some other aspect of the SEC's arcane rules or something from FINRA, it's not because I'm trying to make you nervous or confused or want to leave the office depressed. It's because I'm trying to give you the framework. And that's what Holly and Teresa are doing as well. But they're also doing is taking you through the mechanics of, okay, how do we obey all those rules and laws, but still get you where you want to go, which is to the independent stage. And that's really the framework we want to set, but also give you some of the mechanics. And also, lastly, talk about some of the questions we get the most, which is, okay, I've decided to go, I want to be independent, how do I get this done? And most importantly, can I take my clients with me? Can I take the information with me? And that's always the one that's the biggest question of all. But so first, before we get there, Buddy alluded to this one in his talk. Well, we want to talk about what's the difference between an independent RIA and someone who is a registered rep for a wirehouse or a bank. Now, we're not going to talk about the hybrid model right now. We'll kind of, since that's in between, we're just going to use those two examples. The analogy that I always use, and that Polly says she's adopted when she's talking to clients as well, is that when you're working for a wirehouse or a bank and you are a registered rep, you have to remember you have two hats on. You're an investment advisor rep under the law, and you are a registered broker representative under the law, those two things. But you are an agent of the wirehouse. And so in that sense, from the legal perspective, you face the client as the agent of UBS, Morgan Stanley, Wells Fargo. Once you go independent and you become an independent RIA, because you've established your own firm, the contract with the client is with your entity, you are now an agent of the client, and you face the world on their behalf. That is the easiest analogy that I can give, and it generally describes the legal difference between someone who's a representative for a wirehouse and somebody who is an independent RIA. Now, what does that mean? Well, it has pros and cons. If you're the agent for, let's say, UBS, you have this massive organization behind you that is, running compliance and that is doing all these things, marketing on your behalf as well as their own behalf, and you're their agent. The con to that is you have this massive organization behind you that's running things on their behalf, and you're their agent, and they can tell you what to do. When you go independent as an independent RIA, it's all you. From a legal perspective, you're the one who holds the contract with the client. You're the one who is now responsible for compliance. You're the one who's responsible for supervising all those employees and making sure none of them are doing anything nefarious under your watch. And if you are a branch manager, you have that responsibility, but even as a branch manager, the ultimate responsibility lies with, in the eyes of the SEC or FINRA, the wirehouse or the bank or whoever you're the representative of. Now it's all you. And that does make some people nervous about going independent. But all of this has been done before, and it will all be done again, and that's why we're sitting here, because it's very doable, and it's not as scary as it sounds, even though this is the point when the beads of sweat start coming down people's brow. So what I would say is, as you're asking your questions of your compliance consulting firm or of your lawyer, breathe and make sure that you understand the context of what it is they're telling you. They're telling you the rules in order to make you aware of them, but then get to the part where you say, okay, how do I navigate those rules? And that's where you start to say, once I get through this transition process, on the other side, that's when I get to experience all those things that the guys in the previous panel talked about. So that's the legal environment that you're dealing with as you're making this transition decision.
So if you're going to make the decision to go independent, you're going to have to first figure out how you're going to file. And there are two options for you, there's state versus federal, and Teresa's going to walk through this for us.
Sure. It's pretty straightforward. It's been laid out very clearly in the rules with the Dodd-Frank changes. As far as state or federal registration, if you're a straight, investment advisory firm, the magic number is $100 million. If you have less than that in assets under management, you're going to start on the state level. And then someday as you grow and you hit that $100 million mark, you will be able to go and register with the SEC. There are some exceptions, and that has to do with hedge funds and private equity firms. I don't know if any of you are doing that right now, but there is an exception there. If you're over $25 million, you are able to register with the SEC as an exempt reporting advisor, which is more of a filing, not so much that you're applying for registration. However, you do follow many of the same rules, and we can get into that a little later. The difference between state and federal, not too much of a difference as far as what you need to prepare with. Obviously, we all are familiar with the CRD, IARD system. Both state and federal investment advisors will use that to file their applications or their ERA applications. What is required when is really the difference. Everybody has an ADV. If they're doing a wrap program, they'll have a wrap fee brochure. But beyond that, there's also your policies and procedures, code of ethics, things of that nature. If you're SEC registered, you're going to do, the only thing they want to see up front is your ADV, the one with all those check-the-box questions, and your 2A, which is your disclosure brochure in plain English. That is really all the SEC wants to see up front, and your wrap fee brochure if you're doing the wrap fee. And the SEC, once you push that button on the CRD system and send in that information, they must respond within 45 days, yay or nay. Very simple. So we do that up front when we're doing for federal, and then we do all the other stuff afterwards. While we're waiting to hear from them, we'll prepare our policies, procedures, our code of ethics, and things like that. If you're a state registered, though, most of the states, and of course, since it's 50, everybody has their own slightly different set of rules. But if you're state registered, more often they want to see all of it up front. They want to see not only the ADVs and the wrap brochures, they want to see the procedures, they want to see the code of ethics, they want to see your advisory agreement and make sure that it complies with any requirements for advisory agreements, which we would, of course, go to legal for. They also require minimum income or assets, and if not, that you be bonded in some instances. And they also require some kind of financial statements, the states, whether it's a balance sheet or income and expense statement. And that will, once again, change state by state. When you send that in to them, they do tend to take a look at everything and will send back comments, most states, not all. And once they've gone through all the paperwork and they've also done the background checks on the persons who are applying for registration, that's when you'll hear back from them whether you're approved or not. From there,
then you have to actually maintain your IA and your compliance program. So here's where we're going to turn to the questions that we all get when we sit down for these conversations. And these are probably, we sit down for these conversations with folks, and they all have a notepad in front of them. They all have these questions written down. We give our thing, and then they start reeling these off really quickly. So they seem to be important. And the first one is, when will my firm know that I'm leaving? Well, this is a big one.
So it depends. When we're filing that application on the CRD system, if I file your U4, because when you're applying for registration, someone with a Series 65, an investment advisor, must be on that application as being a party of the entity that we're registering. The minute I submit that U4, it can be seen by your alternative, whoever it is you work with right now. So if you're trying to hide things, it becomes a case of waiting and seeing until everything's ready and you're ready to pull the trigger and start reaching out to clients. But if your firm knows and you've made arrangements and everything's going along smoothly and you're coordinating things, it really does make a difference.
And I think that we talked about yesterday, this is really a kind of a case-by-case thing. It really depends on your personal circumstance, whether you want your firm to know that you're leaving and whether you don't. And if you don't, there are things that can be done to kind of mitigate the Series 65 piece and then seeing your U4 and that sort of thing.
Yeah, I would say one of the things as you're preparing to make this decision, and let's say you've decided you are going independent, as you're preparing for the day when you're going to leave, the first thing to do is to pick the day when you're actually going to exit and work backwards. So let's say you want to leave on May 15th. Then you're going to work backwards and say, what do I need to do by then? I need to have my ADV filed 30 to 45 days for approval. What do I need to do for that? In making all those decisions and putting that calendar together, you're going to be looking at your compliance policies for your current firm. You're going to be looking at your own contract with your current firm because most likely it has a notice requirement in there. And typically it's about 30 days. It can be sometimes longer, but maybe not. There are also going to be terms in there about what you can and cannot do while you're employed by that wirehouse or broker dealer. And you're going to want to pay attention to all that and be communicating with your lawyer. That's not just a selfish pitch. That's actually true. And your compliance consultant, and let them read those and help you work through that. Because you're going to have to be making decisions about, do I want to tell them earlier than the 30 days? Do I want to go with the 30 days? I am not advising this right now as the attorney. Some people say, well, never mind the 30 days. I'm just going to go ahead and tell them, 5 days before I'm going to leave or whatnot. So, those are the kind of decisions you are going to make. What are the effects of those decisions are always the follow-on question, which if you're not asking that follow-on question, I'd be worried. The effects are going to depend. What has been your relationship with this broker dealer that you are leaving, with this wirehouse, with this investment advisory firm that you have been a part of? How long have you been there? How long have you been a representative? Have you recently switched from another broker-dealer investment advisor to the one you're at now, and then you're going to go independent? All of these factors will play into the decisions of timing. And the other issue is, at no point should you say anything to your clients about this until you leave, unless we have certain permission from the place you're leaving, because you're still under all the regulations while you're still a representative of that wirehouse. So that's kind of the issue, that the chicken and egg game that gets played is, well, if I can't tell the clients where I'm going, or if I can't tell the clients what I'm doing, how do I do this? Well, you're going to do as much prep as you can before your exit date, and then on your exit date, you're going to have a package ready. And you're going to say, this is what I can and cannot do. with this package and send this off to my clients. And we're going to even have to think through that, because that's an issue of, what are you allowed to do under the regulations and under their policies?
Well, not only that, but also whether your agreement with your firm has a non-compete or a non-solicit. And that is also determined on a state-by-state basis. Some state non-competes aren't really always solid, but others, a non-solicit is stronger. And what does your agreement say? And they're a lot stricter these days about having those in there than they were before.
Right, and Teresa, to that point, that's where you probably have all heard of the broker protocol. The broker protocol was developed several years ago. I'm losing count as to how many now, by the three of the large wirehouses that kept losing representatives to each other. And quite frankly, they stopped paying all the lawyers that they were paying to sue each other for the representatives moving from firm to firm, and came up with this almost on the back of a napkin written protocol that said, okay, we'll let a representative leave and take this information, client name, client contact information, and the account names, not the account numbers, but the account names. And if they leave and they solicit the clients after they've left and tell the clients where they've gone after they've left, then we will waive our non-solicitation provisions in their contracts. That's essentially what the protocol did. Now, there are other aspects of the protocol that need to be talked about if you're going to rely on it, but essential, that's what it said. Now, that was between three wirehouses. The protocol now has over 3,000 entities that have joined it, and many of them are investment advisor shops, registered investment advisors. And so they are taking advantage of the protocol as well. And it has not yet become an industry standard. The courts have not ruled that it basically trumps the solicitation provisions in any circumstance. But it has become the industry standard for, if we want to play it safe, this is what we do. We make sure that your new firm is a member of the protocol, and that your old firm is a member of the protocol, which is required. Still. Yes, we'll get that's becoming an issue. And if so, then we're going to stick to the protocol in terms of how we tell your clients that you've left. Now, there are other ways to do this if you have a friendly relationship with your current firm. And that if you do have that friendly relationship and they are willing to let you go in a friendly manner, we don't have to be so rushed and secretive about it, and don't have to wait until the last minute to tell the clients. But that's, again, we have to be very careful about that, because people can change their minds. And people who are in charge can leave positions, and new people can come in those positions. And unless you have things in writing, that's what your lawyer's always going to tell you. Have something in writing. Get me an email. Get me something, preferably with a signature on it. That would be awesome. Then you have to worry about the fact that, okay, somebody told me it's okay. I called, my guy who, I know over at the head of the department at Morgan, and he says it's great. Using Morgan as an example, that's not a real example. That's great, but we need something more than that if we're going to go, if we're going to do this in a mechanical way, different than taking advantage of the protocol. It's there, we use it, and we use it for a reason.
So bringing up the protocol brings up another question that we always get, which is, what do I get to take with me? What information do they get to take with them when they leave to go to independent?
Mm-hmm. Do you want to take that first?
Okay.
It depends.
It's pretty basic. It's not like you're going to walk out with your files. Most of the time, they would just let you go with name, address, phone numbers, emails. They're not necessarily, you're not going to be bringing your file cabinet with you, unless, of course, there's a slightly different arrangement. I mean, that's when you're strictly, you're a corporate investment advisor, not semi-independent.
Sure. So we see lots of independent models where they have a contract with their firm that gives them a a little bit different take on that. And it's not that they can easily take the files from one to the other. You still have regulations that apply of sharing information between two entities that don't do business together. So there's still regs that apply here, and so there's still a lot of nuance to it. But yeah, depending on your arrangement with your existing firm, you may be able to take more than you think, more than you think.
Well, and the reason for this is because, again, in the eyes of the SEC or FINRA or the CFTC, if that regulatory agency is involved, remember that all the records, saying it 3 times,
You mean
all the records, whether they're on your property, in your office, or in theirs, are theirs, because they're the broker-dealer or the investment advisor that has the client relationship per the contract. And so, you know, in many of the independent RIA models where you have an independent, a group that's an independent contractor, but they're still investment advisor representatives of a wirehouse or bank, they may have records on at their location. And I've often had them say, well, we have them in our filing cabinets, or we have them on our computers here. Yes, you do. And that wirehouse has permitted you to do that, but that's still theirs in the eyes of the SEC and FINRA and under the law. So hopefully your contract with that wirehouse says how those records will be dealt with when you decide to leave. And oftentimes it'll be friendlier than what we have to deal with if you're just exiting, as you said. If you're just a corporate representative and you're leaving the wirehouse and we have to go through the protocol, it will be friendlier and we can rely on that contract a little more. But I have a tendency to be a little cautious, even in those circumstances, for the exact same reasons. Contracts can be interpreted in a lot of different ways, and people can change, you know, at the top, and therefore we always want to be careful that we follow the steps, you know, as conservatively as possible, so that once you've gotten the exit, you're finished, you're done, you don't have to deal with it anymore. You can sleep at night. You don't have to think, what could happen afterwards? You know, how many more years am I going to have to think about this? You know, I want the answer to be, as much as I can, none. You're gone. You're done. You just go forward and have your business. But that's what we need to be careful about.
So, as I said, these are usually hour to hour and a half conversations, and I think I've gotten the time's up flag. So, please know that all of our contact information is out there with the webinar information, and we are happy to take your calls, answer your questions anytime about any of these topics. Maybe that you call an Oyster person and they say, oh, no, you're going to need to talk to a lawyer. And it may be that you call the lawyer and they say, oh, no. Go talk to Polly or Teresa. So, but feel free to reach out to any of us. We'll get you the answers that you need. I would like to ask Karen a question before we wrap up.
Nobody has any legal or compliance questions?
Oh, wait a minute. Custodians are all about that. Panels versus panels here.
For those who can't see the audience, the custodian representative can. So, yeah, go ahead.
Go right ahead.
Earlier you mentioned that when you file with 65, some of the Series 65s will be attached to the application. But let's say, for instance, you've got a advisor who has a big, he's leaving under the darkness of night kind of thing. He doesn't want to be spotted. Let's say he wants to get, because you can take a 65, that's a state exam that doesn't need a sponsor. Just take it on your own. So suppose someone took a 65, who they're going to hire as their educator for enrollment or something like that. Could that person file it?
Yes, so that would be where you worked with your compliance consultant, whoever that might be, or your law firm to figure out how you're going to address that issue. Because the other problem that you run into is the state won't let you hold two, won't let you be registered. Not in the state. Some states, certainly in the state of Virginia, you can't be registered with your existing firm and register with your firm that's being reviewed. So you have to get someone else to carry that.
They don't even give you like a sharing period.
No.
It's like, got to cut it off.
It is no question. They are not under common ownership.
Another aspect of that, too, has to do with your chief compliance officer. You're also required to have a chief compliance officer listed on your application, and that is state or federal. You can do that in various ways, whether, you know, if you're going to be the compliance officer, once again, it would tip them off, but if you have a partner or your consultant or your law firm possibly could hold that on a temporary basis. until you're ready to move.
This might be an awkward question to express, but and I will preface it with the fact that I believe we should embrace regulation. But talk to sort of the efficiency of compliance to your schedule in the RIA world versus the efficiency of compliance, inefficiency of compliance in the BD world. You have a pie of time. You have X amount of time to spend with your clients and Y amount of time for compliance. But making your compliance life in your own world more efficient when the wirehouse is who determines, we did it, when the wirehouse or the broker-dealer is who determines how much time you spend on compliance otherwise.
Sure.
So that's important because you spend that time you pick up concentrating on your client.
Absolutely, absolutely. If you can move to a model where your compliance program runs efficiently, then that's absolutely much more time that you can spend with your clients. So it depends on how you set it up, whether you're going to choose to be your chief compliance officer, whether you're going to choose to outsource that role, or whether you're going to choose to just have compliance support. Any one of those would greatly affect the time that you had to spend with your
most of y'all came from big houses, and so, well, some of you did. But is it? Do you see in the RIA world a better, more efficient way of embracing regulation than in the BD world?
From my perspective, it's kind of 6 of one, half dozen of the other. The SEC is very gray, whereas FINRA is very black and white. Well, that's an advantage on the FINRA side because I know exactly what's expected of me. I just check the boxes and I do exactly what they tell me. It takes a lot of time, but that's what I do. On the SEC side, it's gray, and I have to interpret a lot more. Sometimes that interpretation and research takes more time, and sometimes I may not get it right. And so then I'm in a battle with them. So I think the best thing you can do is find some resources to help you. Find someone who can help you, or take on, accept that you're going to have to take on time to do that research yourself.
Actually, and not only to that, but just realize that you are going to have to spend time on compliance. If you're a small shop, it will take time. You should set aside time every month, every week, a couple of hours. Don't save it up. We walk into firms all the time who call and say, help me, and to them it's just like something I have to do, and they don't really give it the attention it requires. So of course I'm saying that as a compliance officer and a CCO. But ultimately, why would you want to lose your business because you didn't take the time to do the testing and the monitoring that you're required to do? So all the rules, and some of the rules for SEC side are gray. There are plenty of best business best practices out there. There's certainly plenty of rules by enforcement from the SEC. So really, ideally, you should work with someone who is experienced in compliance to set up your program. And then from there, we always recommend that they kind of guide you, at the very least, guide you through the year to show you what you should be doing on an ongoing basis. Those tasks and testing that are done, daily, weekly, monthly, quarterly, annual reviews, things like that. Because of course, obviously, as a startup, economics comes into it as well, and being able to afford the ongoing compliance, outside compliance support. So you're obviously, we're all watching our bottom line. But even at a minimal amount of hourly work, someone can help you and really help you stay on the right course. I've had clients whose worst fear as they get bigger, when you're little, you don't worry about it as much, but as you get bigger, they get more nervous. The more advisors they have, the more assets, the more products. If they're doing, like insurance and BD as well, and it keeps them up at night. So at a certain point, when do you not have enough time and you have enough income that you're ready to bring on that full-time person, either as an employee or as a consultant, is something to always, you'll think about as you go along.
I would say it is a factor that I've seen with some of my clients who have decided to stay as independent contractors but full reps of a wirehouse or a regional BD. They didn't want to have to take the responsibility of the full compliance mechanics on themselves. They liked the fact that they had behind them a compliance regime that was developed by a large shop. I would say the pros and cons that I've talked through with those clients are typically what happens when you have a large shop is their compliance, their entire compliance system is designed around the fact that it's a massive organization. And it's trying to watch a lot of moving parts at the same time. And so that can become frustrating. The compliance policies and procedures you're going to set up as a small shop RIA are going to be tailored to what you do. And so there's going to be a lot of upfront pain, but at some point it normalizes. And you start to get into the kind of routine of what has to happen. But if you experience significant growth, obviously you're going to have more pain because you just have to keep tailoring that compliance policy and how you run your firm towards the size and the products that you offer. But again, that's also a sign of your growth. So there are definitely pros and cons to it, but I think that's what we were talking about there and what the previous panel talked about. There are several, not just lawyers and compliance consultants, several resources that you can tap into now that just were not there 10 to 15 years ago.
Other questions?
Other questions?
Great.
I think that's it. Thank you very much.